The Service Contract Act, or SCA, is a crucial federal law that impacts thousands of businesses contracting with the U.S. government. If you're involved in federal service contracts or considering bidding on one, understanding this act is essential for your success and legal compliance. The Service Contract Act, also known as the McNamara-O'Hara Service Contract Act, was enacted in 1966 to ensure fair wages and benefits for service employees working on federal contracts. It applies to contracts exceeding $2,500 for services performed within the United States. At its core, the SCA requires contractors to pay their service employees at least the prevailing wage rates and fringe benefits for similar work in their locality. These rates are determined by the Department of Labor and are specific to each contract. Let's break down the key requirements. First, contractors must pay at least the federal minimum wage of $7.25 per hour. They must also provide overtime pay at 1.5 times the regular rate for hours worked beyond 40 in a week. In addition to wages, contractors must offer fringe benefits. This can be in the form of health insurance or an equivalent cash payment, currently set at $2.56 per hour. These benefits apply to all hours paid, including holidays and paid time off. Proper employee classification is crucial. Contractors must accurately match job tasks to the Department of Labor's labor categories. Misclassification can result in severe penalties. To ensure compliance, contractors should take several steps. First, thoroughly review contract solicitations for SCA applicability. Use the Department of Labor's Wage Determinations online tool to understand the required wage rates for your contract. Maintain detailed records of wages, benefits, and job classifications for at least 3 years. This documentation is vital in case of an audit or investigation. Post wage determinations visibly at work sites and provide written notice to employees about their rights under the SCA. Ensure that any subcontractors also comply with these requirements. Non-compliance with the SCA can have serious consequences. Penalties may include contract termination, payment of back wages, and even debarment from future federal contracts for up to 3 years. The Department of Labor has increased its enforcement efforts, including more frequent audits and enhanced whistleblower protections. To avoid these penalties, contractors should create a dedicated SCA compliance team or consult with legal experts familiar with government contracting regulations. Remember, the SCA applies in addition to other federal, state, and local labor laws. Contractors must ensure they're meeting all applicable legal requirements. In conclusion, the Service Contract Act plays a vital role in protecting workers' rights and ensuring fair competition in federal service contracting. By understanding its requirements, implementing robust compliance strategies, and staying informed about wage determinations, contractors can successfully navigate the complexities of the SCA and build strong, compliant businesses in the federal contracting space.